Welcome to this 2021 Legislation and Policy Update webinar on the changes resulting from the Government of Alberta's implementation of Bill 47, the Ensuring Safety and Cutting Red Tape Act in early 2021. This webinar will provide you with an overview of the legislative changes and summarize how they affect you and your injured workers, highlight your responsibilities under the new legislation, and provide you with the resources to help keep you informed through these changes. Egregious conduct and the duty to cooperate are covered in detail in other webinars in this series. Legislative changes occurred in January and April of 2021. 4 of these changes were open for consultation from January 15th to February 15th. These included developing policies and procedures for egregious conduct and the duty to cooperate, establishing the role of the Fairness Review Officer, and incorporating our philosophy on maximum compensable earnings into our principles. First, we'll present a summary of the legislative changes in place as of January 1st, 2021. The following changes were put in place for January 1st, 2021. Previous legislation based on the Cost of Living Adjustment, or COLA, calculations on 100% of the change in the Alberta Consumer Price Index. Bill 47 changes how those calculations are made. Each year, the COLA will be set by WCB's Board of Directors. The COLA for 2021 is set at the Alberta Consumer Price Index minus 0.5%, which equals a 0.84% increase on any COLA calculations made in 2021. Legislation changes in September 2018 removed the maximum compensable earnings cap for workers, and they were eligible for 90% of their net wages with no maximum. This new legislative change reinstates the cap. The maximum compensable earnings rate is set by WCB's Board of Directors and is set at $98,700 in 2021. This cap amount will be reviewed yearly and aims to provide the full value of wages for at least 90% of Alberta's workers. This year's maximum amount covers full wages for approximately 93% of Albertans. Historically, if an employer suspended a worker without pay for disciplinary reasons, the WCB viewed that as the employer removing modified duties, and the worker would be eligible for wage replacement benefits. A policy revision outlined in Policy 0405, Part 2, Application 4, Question 8, states in part, for the purposes Section 56, Subsection 14, WCB does not consider it a withdrawal of modified work if the employer temporarily suspends the worker for disciplinary reasons, provided the period of suspension is consistent with the employer's normal practices. This means that if you suspend your worker without pay for disciplinary reasons while they are on modified work, the WCB will not reimburse the worker for lost wages during that period of time. We will get into more detail on the changes to the psychological injury coverage shortly, and the egregious conduct is discussed in further detail in another webinar in this series. In this section, we will cover changes to the presumptive coverage for psychological injuries, which came into place on January 1st, 2021. Under previous legislation, all workers were covered under the presumption for traumatic workplace injuries. As of January 1st, 2021, the presumption only covers first responders, which are firefighters, police officers and sheriffs, emergency medical responders, primary care paramedics, and advanced care paramedics. It also applies to correctional officers and emergency dispatchers. It is important to note that all workers can be covered for work-related psychological injuries through WCB's normal adjudication process. It is only presumptive coverage that changed. The presumptive coverage supports that if a worker experiences a traumatic psychological event and has a diagnosed psychological injury, the WCB will presume that it arose out of and occurred in the course of employment, unless the contrary is proven. There are other changes to psychological injury policy too. Traumatic workload and interpersonal events are no longer included in the definition of traumatic in policy. Interpersonal relations between a worker and their coworkers, management, or customers may be traumatic when they result in behaviors that are aggressive, threatening, or abusive. They must also meet the overall definition of a traumatic event. This means a traumatic interpersonal relations event must be aggressive, threatening, or abusive, as well as sudden or unexpected, frightening or shocking, having a specific time and place, and involve actual or threatened death or serious injury to oneself or others, or a threat to one's physical integrity. We also need a confirmed diagnosis of a psychological injury. This could include sexual assault, including groping, inappropriate touching, as this is a threat to one's physical integrity, verbal threats of assault or violence, or workplace violence. Further examples include threatening to hurt the worker and their family, threatening to come back to the workplace with a weapon, or non-verbal physical gestures that are threatening in nature, like lunging at someone with a weapon or running towards someone with fists pumping towards them in the air. All other interpersonal events and workload now fall under the chronic onset provisions of the psychological injury policy. Our chronic onset psychological injury provisions outline that a psychological injury is compensable when it is an extreme emotional reaction to an accumulation of a number of verifiable work-related stressors, a significant work-related stressor that has lasted a long time, or bullying or harassment. The policy defines bullying or harassment as a repeated incident of objectionable or unwelcome conduct, comment, bullying, or action intended to intimidate, offend, degrade, or humiliate a particular person or group. So this means it must be repeated incidents of bullying or harassment, not just a singular event. For an event to meet the policy criteria of bullying or harassment, the mechanism of injury must be capable of causing psychological injury to a reasonable person. In addition, the act of bullying or harassment must be reasonably directed towards the claimant. WCB looks at different standards of causation depending on whether the mechanism of injury is classified as traumatic or chronic onset. For traumatic onset claims, we use the but-for test. Work doesn't have to be the only factor, or even the primary one, for the injury to be compensable. It must, however, be a necessary factor. If the injury or disability would have happened anyway, regardless of work factor, it is not compensable. The worker could have numerous stress factors in their personal life, and were just getting by and coping. But for the traumatic work factor, they would have been able to continue to get by and cope. For chronic onset claims, we use predominant cause. It is not necessary that the proportion attributable to the occupational exposure is a certain percentage, such as 50% or more, provided that the occupational exposures are the strongest cause. If the same worker with numerous personal stress factors has a chronic onset claim, WCB must confirm that the work exposure is the strongest cause of disability. WCB might require further assessment to determine this. If you are interested in more detailed information on how WCB adjudicates and supports workers with psychological injury claims, we encourage you to access our employer fact sheets or attend our Psychological Injury in the Workplace seminar. You can register for this free seminar online through our website. WCB's partnership with the University of Fredericton offers Alberta employers reduced rates to the university's Psychological Health and Safety in the Workplace online certificate program. If you're interested in enrolling, please contact us to learn more. Other legislative changes were effective April 1st, 2021. The duty to cooperate came into effect April 1st. It is covered in detail in a separate webinar in this series. We will discuss the remaining changes that occurred for April 1st, 2021 in further detail now. This includes changes to the employer's responsibility to cover a worker's employment health benefits while they're away from work due to their workplace injury, changes to appeal timeline, establish the role of the WCB's new Fairness Review Officer who oversees the new Fair Practice Review Center, and other changes that impact your workers' compensation system. Prior legislation made it mandatory for employers to provide continued employment health benefit coverage for their injured worker for up to 1 year following the date of the worker's accident. This legislation continues to be in place for claims with a date of accident between September 1st, 2018 up to and including April 1st, 2021. Bill 47 has now made this a voluntary practice for employers for any new claim with a date of accident occurring on or after April 2nd, 2021. Workers were entitled to the same health benefits that they and their dependents had on the date of the accident. This includes dental, vision care, medications, hospital services, health services, and paramedical services. When a worker or employer disagree with a decision made on a claim or the employer account, they continue to have 1 year to request a review of that decision through the Dispute Resolution and Decision Review Body, DRDRB. The change in legislation impacts your timeline to request an appeal to the Appeals Commission. If the DRDRB decision is dated on or after April 1st, 2021, the window to appeal to the Appeals Commission is now 1 year. If the DRDRB decision is dated from September 1st, 2018 up to and including March 31st, 2021, the window to appeal to the Appeals Commission remains 2 years, based on legislation in place at the time of the decision. Appeals Advisory and Fairness Review Services have transitioned to the Appeals Commission and to WCB. The worker and employer appeal advisors who provide appeal advisory services continue to operate as an arm's length program of the Government of Alberta under the Appeals Commission's new advisor office. These services remain free of charge. WCB procedural and behavioral fairness reviews are now provided by the new Fair Process Review Center, which I will discuss further in the next slide. Fairness reviews related to the Appeals Commission or the Medical Panel Commission will now be addressed through the Ombudsman Office. WCB Fairness Review Services are now provided by a new fairness review body called the Fair Process Review Center, or FPRC. The FPRC is overseen by a fairness review officer that is accountable to the WCB's Board of Directors. They review and make recommendations to the board related to administrative fairness and processes used to reach decisions, breaches of Code of Rights and Conduct. The FPRC will review the fairness of the adjudication process only, not the decisions themselves. A separate process for reviewing decisions remains in effect through the Dispute Resolution and Decision Review Body and the Appeals Commission. The fairness decisions and claim account decisions are entirely separate decision streams. WCB staff involved in resolving fairness concerns are not involved in decision-making related to the review of a claim or account-related decisions on the same matter or file. Administrative fairness will be assessed within two main categories: procedural and behavioral. Procedural fairness looks at how decisions are made. Were they timely, effectively communicated, made with correct information and without bias? Behavioral fairness looks at how you were treated, including whether WCB staff followed the Code of Rights and Conduct, which is available on our website. If you have a fairness concern, we ask that you first call us and discuss it directly with the individual if you're comfortable doing so. If you do not feel that it is resolved, you can also speak to their supervisor and/or manager. To initiate a fairness review, contact the FPRC within 60 days of the interaction or decision that led to your fairness concern. An early referral will optimize the FPRC's ability to resolve your concern and restore your trust in the workers' compensation system. If you contact the FPRC outside of the 60-day window, you may request that they extend the time period. An extension may be granted when there is a justifiable reason for the delay. For example, if you relied on someone that you trusted to bring your concern forward on your behalf and they failed to do so, and once you became aware, you took reasonable and timely action to contact the FPRC, it is reasonable to request an extension. FPRC decisions related to extensions can be reviewed by the Fairness Review Officer if they are within 1 year of the interaction or the decision that led to your fairness concern. If the FPRC determines an unfair practice has occurred, they will help resolve the issue as quickly as possible. Management of the roster of the independent medical examiners also moved from the medical panel office to WCB. If WCB requests an independent medical exam, the injured worker has the right to select the physician of their choice from the roster of physicians qualified to conduct the exam. Some specialties may only have one available specialist, so an option might not always be available. The core services delivered by the medical panel's office transitioned to the Appeals Commission and will be provided by the medical panel's commissioner. The commissioner continues to assist in the resolution of differences in medical opinions related to an injured worker's claim. Let's conclude with a brief discussion of available resources. You can stay informed and get updates when changes like these happen in the future. WCB's website is updated regularly. Visit our legislative changes page to continue to stay informed. You can download fact sheets which explain these changes and view the policies that guide our decisions. You can also sign up for our email newsletters and receive important business updates straight in your inbox. To sign up for policy notifications, view current policies, and to provide comments and feedback on open consultations, visit our website. Simply search for What's New in Policy. We also provide numerous other virtual seminars at no charge to you. Please check out our seminars and workshops page on our website and register. WCB now has a new employer app to make it easier for you to pull clearances, check your account balance and make payments, update your account, and to contact us. Check it out in the Apple Store or on Google Play. Thank you for watching the webinar. For more information on the duty to cooperate and other legislative changes made in 2021, please view the other videos in this webinar.